Today we're going to talk about Homestead, which is a vastly misunderstood subject, partly because there are multiple definitions. Today's discussion of Homestead is specifically under Florida law. If you're thinking about Homestead in a state other than Florida, please consult someone who practices there to tell you about it. So, under Florida law, Homestead has at least 3 primary definitions, and we're going to hit them all in the next few minutes, probably about 20. So historically, Homestead in Florida was granted to provide important protections to settlers in about the Civil War era, actually a little before that. So it goes back a long, long way prior to the time that we were even a state. It was first to prevent forced sale by creditors, and second, to provide for a surviving spouse, usually the wife, and give the family a place to live. Now, this was really important because if you think about Florida in the mid-19th century, that's the 1840s, 1850s, 1860s. For reference, that's the ending decade is about the time of the United States Civil War. So think back then. Think of what Florida was like. It was a mosquito-ridden, alligator-populated swamp that had been settled a long time ago by the Spanish and now was a territory of the United States. There was no electricity, also known as there was no air conditioning. People did not want to live in Florida because it was hot. So the government decided they needed to do something to encourage pioneers to make their stake their claim in Florida. And so they, in 1845, before Florida became a state in 1845, the U.S. government, took action to allow settlers certain advantages if they would come and try to live in the state which we now hold dear. This way, with a homestead grant, if the head of the household, usually the man, completely failed in whatever business venture or employment they were trying out here in Florida, at least the family would have a home. I can imagine in my mind these guys going, hey, let's go down to that hot state and really make a go of it. And the wife saying, there is no way I'm leaving Virginia, the Carolinas, or Georgia to go south where it's even hotter. And so the government said, well, if you don't do well, you at least get to keep your house. This was codified by the United States Congress in the Florida Homestead Act of 1862. Florida's love affair with Homestead was further codified in Section 7 when they added Article 10 of the Florida Constitution on November 6th, 1934. So prior to 1845, this was in effect. Not until 1934 did it become a part of our Constitution. There are no rights you have that are stronger than those granted in the Constitution. So Homestead is a wonderful and beautiful right that we always have. In fact, our Florida Supreme Court called it the greatest benevolence ever shown by the people of any state toward the exemption of homestead from taxation. That's right, we have it good with regard to our homesteads. I mentioned that first, the second is that the property can't be transferred without both spouses signing. We're going to go into all 3 definitions a little bit, and we'll drill a little deeper into that in a moment. So, the 3 types of homestead in Florida. 1, exemption from forced sale. 2, restriction on transfer and devise. That means selling or mortgaging. And 3, the one we usually think about, and the one that you get the card in the mail annually if you're a Florida homeowner, a property tax exemption. So first, exemption from forced sale. The exemption from forced sale protects a Florida homeowner's primary residence, and by the way, only the primary residence, from a forced sale by a creditor. For example, if someone gets a money judgment against a Florida homeowner, the judgment creditor will not be able to satisfy its judgment. A different way of saying that, will not be able to collect against the person's homestead. So they could go after a car, they could go after adult toys, they could go after bank accounts that are not properly asset protected, but they cannot go after a person's homestead. All right. This protection is extremely strong and has been used and worked under many dubious circumstances. You yourself can probably recall circumstances under which a celebrity has moved to Florida, dumped all their money into a really big or really expensive home, made it their homestead, and thus protected themselves against judgment creditors. If you can't think of any, send me a private email, john@rocksolidlaw, and I'll share 2 great examples with you. But here on the Zoom Zoom webinar, I don't feel any need to drag those people further through the mud. Now, with regard to this first definition, there are several rare exceptions, and you need to be aware of them. Who could collect against the homestead? Who could collect against your home? Unpaid property taxes. You cannot get away from the tax man. The tax man, federal and state, can come after your home. You've heard of a tax deed, an auction on the courthouse steps for failure to pay taxes. So your home is subject to taxes, so those should be a priority. 2, a defaulted mortgage debt. Why? Because you gave the mortgage holder, the bank, a lien against your property. And if you don't pay the bank back for the money they loaned you to buy that home, they can collect against the property. And finally, unpaid obligations contracted for labor performed on the homestead. And I think this is just a fairness statute. That is, if you hire somebody to come improve your homestead, they can have a lien, a notice of commencement. You've heard of that kind of thing. They get what's called a mechanics or contractor's lien, and they too can collect against the house. So be careful when you enter contracts with people for repairs and renovations on your home, because they have the ability to collect against your home. All right? The exemption from forced sale not only protects the homeowner, but also protects his or her heirs, that could be children, to inherit the property free of the homeowner's creditors. All right? This is part of asset protection, estate planning, and probate all wrapped into one. Your heirs, your kids, can get the house without having to pay those creditors other than the exceptions mentioned. Obviously, the mortgage runs with the land. The contractor's lien would, and taxes. So that's number 1. Number 2 are restrictions on transfer. And this is the one we talk about the least, but it's really important. So this restriction prevents a Florida homeowner from transferring his or her homestead property without the joinder or waiver by a spouse. What I just say? That means both spouses have to sign to transfer a homestead property on the deed. In addition, absent a waiver, the property must pass to the homeowner's surviving spouse following death, absent a waiver. So there is some estate planning that can avoid that, but generally they are going to inherit at least for a lifetime. This is why we have the spouse at a closing. People often are upset with us for requiring a spouse who's not on title to come to closing to execute the deed, if nothing else. Had that instance just yesterday. The spouse has to sign, or otherwise the title is not fee simple, it's not free and clear, and it's not insurable with a title insurance policy. There is also a restriction on devise for a Florida homeowner who dies survived by one or more minor children. There's a restriction on homestead devise for a Florida homeowner who dies with 1 or more minor children. Why? What's the public policy? We want the kids to have a house, right? We want them to have a place to live, and we're going to give them that place to live if one of their parents has died. This restriction is absolute. And the homestead passes to the decedent, that's the dead person's, minor children by operation of law. Okay, we're going to take care of those kids. These restrictions are designed to protect widows and orphans. And in these days, it could be a widower more often than it used to be in the olden days, but are often a trap for the unwary when it comes to estate planning. Holding title to your home can get really messed up if estate planning isn't done properly. And this poses difficulties when dealing with homestead property during the administration of a decedent's estate. That's saying that during the probate process, there can be difficulties if we didn't plan for it properly. Planning, not hard, easily done, but when not done, these statutes and even our Constitution come into play for an intestate or even a testate, meaning a will or not having a will, a state that has to go through probate. Best practice, in my opinion, for many, many families, avoid probate. How do you do that? With a trust. We can tell you all about that if you're interested. Why does this restriction exist? If it didn't, then one spouse could transfer or mortgage property without the other one even knowing. A husband or a wife could put a mortgage on a property and get the money, or could transfer the property without the other spouse even knowing. I've even been asked in my practice, can I sign for my spouse? Can I sign for my wife? Can I just go ahead and sign for my husband? I mean, we do it all the time anyway, right? No. On real property matters, you absolutely cannot, and anyone who would notarize such a signature would be a fool. Early in my practice, 25, 30 years ago, I actually had someone come to closing with a woman who posed as the wife with an identification card. Fortunately, we caught him and the transfer didn't take place. And so that spouse was protected as she should have been under the law. All right. The one everybody wants to talk about because it's the one where the money is the property tax exemption. When most of us talk about homestead in general conversation, we are not talking about asset protection of our home. We are not talking about an exemption on transfer, but we're talking about the third category, the property tax exemption, right? So every Floridian pays a lower tax or pays on a lower value for their homestead than they do for a rental property or an investment property, a vacation property, any kind of commercial property, any kind of property other than the homestead. So most people think that it's the most important area of Florida homeowners. It's the property tax exemption and the related Save Our Homes law. So the constitutional property tax exemption provides that the first $25,000 of a Florida homestead is exempt from all property taxes. An additional reduction of up to $25,000 applies if the home is worth at least $50,000. However, the second exemption only applies to non-school taxes. Okay, so you get to pay less taxes as a Florida homeowner, all right, than someone who has their vacation house here or something like that. Obviously, the policy is that we want to help our own homeowners, our residents of Florida out and raise taxes based on folks who are able to afford a vacation house here or those who are investing. The Save Our Homes law cap begins when the county grants the initial exemptions and caps the increase on the assessed value of homestead property to the lesser of the rate of inflation or 3% per year. What on earth does that say? Basically, once the fair market value or assessed value of your home is determined by the property appraiser, it is not going to go up for tax purposes by more than 3% a year. It's important in Florida because often in particular markets, the value of Florida property goes up a lot more than 3%. As you know, a lot of people come here to retire or we have aging in place population, and those folks were in danger of losing their homes. So we had to give them a break, keep them in their houses. Right, typically the appreciation in Florida has outpaced this cap, and it created a big burden particularly for long-time Florida homeowners. In addition, if a homeowner moves residences but stays in Florida, up to $500,000, $500,000, $1 million of Save Our Homes cap may be ported to the new property. Portability is a subject outside of the scope of today's discussion, but it is really, really important for a Florida homeowner who's either upsizing and downsizing to take advantage of, so that he or she can continue only to pay the fair taxes and not voluntary taxes on top of that. Homestead issues can be difficult to navigate. Those with questions should contact a firm with attorneys who specialize in both real property and estate planning. And of course, those along with business law are the primary reasons for existence of rock solid law. I'm going to wrap up in a moment, but I'd like to give all of you the opportunity to type in a question, if you have any, on Florida homestead law into your chat box, which can be found at the bottom of your Zoom screen. It's amazing the minimal expertise I have gained in Zooming over the last month or so. But as a recap, the three areas, I am so sorry, I got my papers out of order over here, are the exemption from forced sale, right? Nobody can make you sell your house unless they have a tax lien, a construction lien, or a mortgage. A restriction on transfer. You can't transfer it without your spouse participating if you have a spouse. And on death, that spouse and any minor children will have a claim on your homestead. And then the property tax exemption, which you really need to take care of because that's going to save you money year in and year out. So far, I'm not seeing any questions. I can't believe I was so clear that you got everything you ever wanted to know about Homestead. Oh, thank you. I do have a question. Let me take a second to read it. Wow, that is a great question. I'm going to restate it. What happens when two single people combine households? Buying a home together. How do you know which 3% cap carryover you would use? Okay, that's a very fact-centric question, but one that happens all the time, of course. When two people decide to buy a third home together, presumably their homestead, the homestead of one of the parties will move to that new home. It is possible, in some instances, those parties will continue to live in separate residences enough to keep two homesteads going. What I would suggest is that the portability calculation be completed for both of the existing properties, the two present homesteads, and that the larger one be converted to the new one. That will get you the greatest savings, assuming that the facts will allow each of them to be ported. There are some restrictions on portability. By the way, there's a 2-year limitation, so that is not something that you can put off. I would be delighted to discuss the facts of that with you at some point if you like. Hope that's helpful. Yes, the follow-up question is, who checks the portability numbers? The tax assessor. Exactly right, which is the property appraiser, right? So you can contest that. I have a client right now who should be allowed to port a lot more than they are presently showing. And so there may have to be some discussion of the just value of that property prior to the sale. And they will either go down and contest that themselves or get us or someone else to help them with it. So yes, that's who determines it. There is a website that the property appraiser has, which has frequently asked questions and a form to fill out for portability. It is a rather confusing and complex subject. Be glad to help with that if anybody needs. Another question's come in. What are the tax breaks for seniors as it applies to homestead exemptions? Yes, we have new tax breaks in effect For seniors under Florida law. I did not prepare the facts and figures and numbers on that. And shoot us an email and we'll be glad to follow up with that. But yes, definitely Homestead is a big reason for the Homestead in Florida is to keep our seniors in our homes. And we have additional protections for them now as a result of the amount of increase in value on their homes. So be glad. There are all sorts of various exemptions from taxes for people like seniors and veterans that need to be considered so that you make sure you get the maximum exemptions allowable under law and only pay the mandatory taxes. If you want to submit a question, please send it to Shelley, that's C-H-E-L-L-E, at Rock Solid Law, and we will be glad to take up those fact-centric, those questions that have individual facts in them offline. So you're welcome. You have a great week too. Next week, we're going to talk about asset protection and how we can help cover your assets so that you are fully protected and that you can pass them forward to those that you love. Our set time for next week again is 9 o'clock on Thirst for Knowledge Thursday when we talk about estate planning issues. I'd also like to ask you to look out in the Ponte Vedra Recorder for the Judge John series. I'm writing about a topic of interest to beaches residents specifically monthly. The first one was about surfboard leashes. The one this month, when published, will be about the sand dunes and what they're for and what the law is regarding staying off of them. Something near and dear to my heart. And then next month, we're going to write about bicyclists and the law surrounding those that we share the road with. Hope everybody got some value out of this presentation. This is John Miller with Rock Solid Law. And please be well, stay safe, and we'll look forward to seeing you either here online next week or some other way soon. Thank you so much for joining us.